So the Supreme Court has made its decision on 4 Second Amendment cases, including 2 cases challenging the ATF's power to regulate. So let's talk about this. But before we jump into this video, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year and employs roughly 400 people within the US. Kershaw produces a broad range of knives to meet every single person's needs. From a $20 knife that you can get at Walmart for a new knife owner to a $200 US made manufactured automatic knife, Kershaw has you covered at every single range. So I highly recommend that you check out Kershaw Knives. I carry them every single day with my EDC. And right now, if you go to their website and use the code SCHOLAR20, you can get 20% off site-wide plus $100 in free shipping. And that offer will last until December 1st. So they are offering you guys a great deal right now for the channel if you use that channel code. So go check them out. And thank you again, Kershaw Knives, for sponsoring this video. So like I said in the intro, yesterday we got some big news out of the Supreme Court. The Supreme Court has decided what they're going to do with 4 Second Amendment cases that were currently pending before them. 2 of those cases dealt with the ATF's regulatory powers, specifically whether or not the ATF has the power to arbitrarily change the regulatory definition of bump stocks so that those items and devices are actually considered and defined to be machine guns. One of the other cases that they have decided on deals with whether or not the state or any state can ban a person forever from purchasing firearms because they have a misdemeanor. And the last case dealt with whether or not the government can use a subjective standard of propensity for violence to deny someone a carry permit. And ultimately, the Supreme Court's decision on these 4 cases ended up being more bad than good, but there was still one case that ended up positive. So first, let's talk about the Supreme Court and what they did with the 2 cases that dealt with bump stocks. These 2 cases challenged the ATF's ability to arbitrarily redefine the term machine gun so that devices like bump stocks are now considered to actually be machine guns within their own right. As many of you may recall, for many years the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun did not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would fall under that definition. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. In the Apashian case, Mr. Apashian purchased a bump stock before that final rule took effect. After the ATF changed that interpretation, he filed a lawsuit against the ATF, which eventually made its way up to the Supreme Court. Then there was a similar case filed by Gun Owners of America, GOA, which also challenged this bump stock rule. That challenge made its way up to the 6th Circuit. A 6th Circuit en banc panel reviewed that case, and on review, the 6th Circuit en banc panel was unable to reach a majority opinion and instead issued a rare 8-8 deadlocked ruling. This deadlocked ruling in the 6th Circuit resulted in no precedential appeal court decision, and by default, the lower court's ruling on this case, which was in favor of the ATF and their new rule on bump stocks, had to be affirmed. And both of these cases, GOA and the Apashian bump stock cases, were before the Supreme Court, and the Supreme Court had to decide whether or not they wanted to review this issue. Well, yesterday we got an order from the Supreme Court after conference on these 2 cases, and the Supreme Court has decided that they are going to deny both of these cases certiorari, or essentially review of this issue. And effectively what happens is the rulings of the lower courts and their findings in favor of this ATF bump stock rule will now remain in effect. This is a really significant loss because we desperately needed the Supreme Court to review this type of issue, this type of case, to help stop the ATF from engaging in other acts. Now, currently there are cases challenging the frames and receiver rule and all these other ATF actions, and there will also likely be a case filed against the pistol brace rule. But right now it appears that the Supreme Court is simply not interested in hearing this type of issue. So I suspect that the ATF will feel emboldened by the Supreme Court not reviewing these issues. They will likely be more aggressive going into next year, and next year going after various types of items by changing definitions and instituting new rules. I think that the ATF will be very aggressive next year because they know right now the Supreme Court does not want to review this type of issue. However, there was a third loss since the Supreme Court also denied review in the Whitaker case. Whitaker involved whether or not the government can use the subjective standard of propensity for violence or instability to deny a permit to carry concealed. Also, this case involved whether or not the government can try and moot these types of Second Amendment cases by granting permits once the government is sued, or by simply changing the overall laws once there is some sort of litigation against the state. And ultimately, the Supreme Court denied review in this case as well. This denial of review is concerning, of course, because right now states like California and New York are changing their CCW laws because of the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruin. Even after Bruin, these states are using subjective standards like good moral character and the qualified person standard to grant or deny permits. This Whitaker case would have stopped those types of semantic games that states are playing, and it would have stopped it right here and now, but the Supreme Court ultimately decided to not take up this case. So that is essentially the third case that we lost right now because the Supreme Court denied review in that issue. And simply the lower court's decision as well in the Whitaker case will now stand as precedent. Now, like I said, it wasn't all bad. There was a slimmer of light, and that was the Supreme Court granting, vacating, and remanding the Morin v. Liver case. GVR simply means that the Supreme Court granted review of the case, vacated the lower court's decision, and remanded the case back down to that lower court to the First Circuit to rehear the case in light of New York State Rifle and Pistol Association v. Bruin. We have talked about this case more and prior on the channel. In fact, my last video that I posted on the channel covered the case in depth. So if you're interested in all the nitty gritty of this case, go watch that prior video. It will be linked at the end of this video. But just understand that generally this case was a challenge to the state of Massachusetts laws, which essentially banned a resident for life from being able to purchase a firearm if they have a qualifying misdemeanor conviction. In this case, Dr. Morin made the mistake of thinking that since he had a Massachusetts carry permit, he could simply go to any other jurisdiction, that he could go to Washington, D.C. and also carry concealed. He made another mistake in going to a museum, and then he decided to tell a police officer at the museum that he was carrying concealed and that he wanted to check his firearm because he saw a sign that said you had to check all firearms. That mistake resulted in his arrest and also a conviction of various misdemeanor charges. This case then made its way through the First Circuit multiple times, through the DC Court of Appeals multiple times, but on various occasions the courts in this case sided with Washington, D.C., finding that the Second Amendment does not protect the right of an individual to carry a firearm in public. Also, in reaching this determination, the First Circuit used the two-step approach analysis, and they found that under intermediate scrutiny, the state here, the ban here in Massachusetts, had an important public interest in preventing people with criminal records from purchasing firearms and therefore was found valid. Well, the Supreme Court recently ruled in Bruin, and that decision directly impacts some key findings in the Morin case. First, the Supreme Court reaffirmed in Bruin that the correct type of analysis when dealing with the Second Amendment is text as informed by relevant history and tradition. Therefore, the Supreme Court rejected the use of the two-step approach and also expressly stated that intermediate scrutiny should never be used in Second Amendment cases. The court also found in Bruin that the Second Amendment is not limited to only being exercised within your own home. In fact, Justice Thomas stated in Bruin that nothing in the Second Amendment's text draws a home/public distinction with respect to the right to keep and bear arms, and the definition of bear naturally encompasses public carry. So the argument that the district court and First Circuit used in this Morin case prior was essentially found 100% invalid under Bruin. And therefore, the Supreme Court in this decision decided to grant, vacate, and remand the case back down to the First Circuit to reconsider the case in light of Bruin. So this case will be relitigated in light of Bruin. Now, one of the strategies we've seen in a post-Bruin world, especially with circuit courts that don't want to deal with these Second Amendment cases, is that they will simply punt them back down to the original district courts. And essentially what that does is it drags these cases out even longer, and it also helps the circuit courts to not have to rule on these issues in light of Bruin, essentially because they know that Bruin will really tie their hands and force a decision that they don't like. But regardless, it's still a positive outcome that the Supreme Court granted, vacated, and remanded the Morin case. But really, out of all these cases, I want to say that one of the most unfortunate things was that the Supreme Court did not decide to take up the ATF's regulatory actions against bump stocks, the ability of the ATF to regulate and redefine terms. That was a case that we desperately needed the Supreme Court to take up. And like I said, now I have some concerns about the ATF being emboldened by the fact that the Supreme Court decided to not take up these cases. And I fully suspect that next year, going into next year, there will be even more rules by the ATF pop up, and maybe the ATF will be even more aggressive in trying to attack and regulate various types of items. So that is what the Supreme Court decided to do with these 4 Second Amendment cases that were pending before them. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this is built by armed scholars, and this nation will be maintained by armed scholars.